Okay, I'll call to order the review and comment hearing for proposed initiative 2021-22 number 61 concerning legal possession and use of entheogenic plants and fungi. I'll start by having everyone introduce themselves. My name is Julia Jackson. I'm with Legislative Council staff.
Michael Dorr, the Office of Legislative Legal Services.
Can the proponents introduce themselves for the record?
Kaylee Nicole Forrester, I'm one of the proponents.
Melanie Rose Rogers, the other co-proponent.
Courtney Barnes, counsel for SPORE and the initiative.
All right. Section 140.1051, Colorado Revised Statutes, requires the directors of the Colorado Legislative Council and the Office of Legislative Legal Services to review and comment on initiative petitions for proposed laws and amendments to the Colorado Constitution. We've submitted our comments in a memorandum that you should have received, and we'll be going over that today. The purpose of this statutory requirement of the directors of the offices is to provide comments intended to aid proponents in determining the language of their proposal and to avail the public of knowledge of the comments of the proposal. Our first objective is to be sure we understand your intent and your objective in proposing the amendment. We hope that the statements and questions in this memo will provide a basis for discussion and understanding the proposal. And we'll just go ahead and start by going over the purposes that we identified, and you can comment on those if you'd like.
The major purposes of the proposed amendment to the Colorado Revised Statutes appear to be to permit the lawful possession, use, cultivation, production, sharing, giving away, and delivery of entheogenic plants and fungi by natural persons 21 years of age or older, to permit the provision of supervision, guidance, therapeutic, harm reduction, spiritual, or supportive services by a natural person 21 years of age or older to natural persons who are engaging in the use of entheogenic plants and fungi, and to permit the lawful possession of drug paraphernalia designed for the use in the cultivation, production, storage, and use of entheogenic plants by natural person 21 years of age or older.
Yes, we agree with those.
Great, thank you. And then we will go through the substantive comments and questions, and you can respond to those if you'd like. You don't have to. And then after that, we have technical comments, which we can read into the record if you want, or if you have questions about them, but we can also just skip those and you can have them for your reference. So the substance of the proposed initiative raises the following comments and questions. 1. Article 5, Section 1, 5.5 of the Colorado Constitution requires all proposed initiatives to have a single subject. What is the single subject of the proposed initiative?
Could you clarify the difference between the single subject and the title itself?
The title that you have assigned here is just a short title for our tracking purposes. It has no legal implication. So the title of the measure would be set by the title board, and they would aim to capture the single subject. So hearing from you what you think the single subject is helps them do that.
So most broadly, our single subject would be an initiative amending the Uniform Controlled Substances Act under Colorado law. If it needs to be more narrow, we can also provide a more narrow one, but that is technically what the initiative is doing.
All right. What would be the effective date of the proposed initiative, and did the provisions apply on or after that date or some other date?
The intent is for the initiative and provisions to take effect immediately upon passage. Do we need to clarify that further in the language to make that intent clear?
I mean, if you want to have that intent clearly specified in the language that the voters would be seeing, yes.
Okay.
And if there is no effective date specified in the language, what would be the default effective date?
Upon the proclamation of the governor, but then there would be ambiguity as to its application if it's intended to apply on or after that date or some other point in time. But the default would be that it would apply on or after the proclamation by the governor.
And can we include the effective date without making it a subsection of that section that we're amending? So it can just be like a second, like a section at the end that says the effective date. Perfect. Okay.
Yes.
Great.
The proposed initiative uses the term natural person throughout. What do the proponents mean by natural person? Is the intent to distinguish between legal entities like a corporation that are defined as a person in Section 24401(8) CRS and an individual? If so, is the intent to exclude business entities from the protections created in the proposed initiative?
Yes, the term natural persons is used with the intent to distinguish between legal entities like a corporation and natural persons. The intent is to exclude business entities from the protections created by the initiative. Would you recommend we use the term individual instead of natural persons?
Whichever term you prefer, because part of the purpose of this hearing is to create a record of what your intent is, and so you've done that, and whichever term you choose, you've now created a record as that you were making a purposeful distinction and why you were making that distinction.
Okay.
Number 4, how will someone obtain entheogenic plants and fungi if they are not available for sale? At what kind of facility or location would someone be able to obtain the plants or fungi?
The intention is to allow for cultivation of these plants and fungi by adults, but not to allow for sale.
Question 5. The proposed initiative permits a natural person 21 years of age or older to provide services to natural persons who are engaging in the use of entheogenic plants and fungi. The proposed initiative does not impose an age restriction on the person receiving the services. Is the intent to allow a person under 21 years of age to receive the services?
The intent is to allow natural persons 21 years of age or older to provide supervisory and supportive services to any consenting natural person engaging in the conduct.
In subsection 18.418, subsection 8 of the proposed initiative, it states that the provisions of subsection 18.418, subsection 7 should not be construed to permit a person to distribute or sell any amount of such natural plants and fungi for remuneration as part of the business promotion or other commercial activity. A, the language does not use the defined term entheogenic plants and fungi. Is the intent to cover the same plants as the defined term? If so, would the proponents consider using the defined term?
Yes, we'll consider it. The intent is to use the defined term throughout the initiative.
Okay. And B, does the language as part of a business promotion or other commercial activity limit the language to a business that does more than sell these plants, or is the language intended to preclude any business activity that would distribute or sell these plants for remuneration?
The intention is to not allow the sale or distribution of entheogenic plants and fungi for remuneration. And then we would like to address technical comments 3 and 6.
Okay. Do you want us to read them, or do you just want to ask about them?
Could you read them?
Yeah, so technical comment number 3 says, for purposes of this statutory initiative, the word shall is defined in section 24401, subsection 13.7, Colorado Revised Statutes. And it means, quote, that a person has a duty. The related word must, which is defined in section 24401, 6.5, Colorado Revised Statutes, means that a person or thing is required to meet a condition for a consequence to apply. Furthermore, must does not mean that a person has a duty.
And yeah, so we were seeking clarification on some of that. Courtney, could you ask?
Sure. So we do use the word currently shall twice up in subsection 7 as well in subsection 8. We were curious if there was an issue with how that could be interpreted, or as to essentially why that technical comment was made or what it applied to.
Yes. So in subsection 7, the phrase is shall constitute the basis for, and so then as have a duty to constitute the basis for. So generally, the common drafting form in that situation would just say constitutes the basis for rather than shall, because there's not really any duty there. And so you will certainly find statutes that were written like that a while ago, and we are doing our best to clean all of that up and not write like that anymore.
Okay, that makes sense.
Yep.
So it would be no conduct permitted by this section constitutes the basis for.
Yes, that's the way that's sort of the modern way that we would write that phrase.
And then for subsection 8 would be nothing in subsection 7 of this section. Is that shall okay there, or?
Yeah,
Okay,
That's fine.
great, perfect. Thank you very much.
And then the other one you said was 6, is that correct?
Correct.
Okay. Would the proponents consider and use the following drafting style of definitions for the definition of entheogenic plants and fungi? So the definition reads, entheogenic plants and fungi means.
Yes, we'll consider this. In drafting it, we have found it likely that doing that will make the subsection 2 sentences. Is that allowed?
Yes. Yes. You can have multiple sentences within the subsections.
Okay.
Okay, great.
Okay. Did you have any other questions or comments for the record?
So the next process would be to submit just the technical changes and the changes we've discussed back to you, or is that not required?
If all the changes you have made are a direct result of this memo, you can go directly to title board.
Great.
If you want to take it through us and make sure of that, we can review it and decide whether we think it needs more comments, or if we don't, then you get a memo saying you can take it directly to title board.
Perfect, thank you
within a
very
few
much.
days.
Thank you.
All right.
Thank you.
That concludes our hearing. I'm going to turn off the recording. Thank you so much.